Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what is called, you have to sit like that. You have been asked to come to court for what is called an arraignment or initial appearance. Now, what the arraignment is, it's an opportunity for the court to tell you what you've been charged with. Make sure everybody have their phone on. It's an opportunity to tell you what you've been charged with, what your rights are, and your options for concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your more serious type of criminal offense, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, when I'm talking about the facts of the case, the possible punishment that a person can receive if they are convicted. When we talk about a felony case, felony cases are divided into 5 categories. Let's start at the top and work our way on down to the bottom. You have capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. Person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, which is a little higher, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. The person is convicted of a second degree felony. The range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment, minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case, so you don't have to worry about those type of punishment. Now, misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor. Now, if a person is convicted of a Class C misdemeanor, the range of punishment is minimum, it's just a fine that cannot exceed $500. You cannot be given jail time for a Class C misdemeanor. You only can be given a fine. Class C misdemeanors are cases that start in the JP court or the city court and they come to this court, and then the range of punishment is still the same. For example, a Class C misdemeanor is not having your seatbelt on, or speeding, or having an expired license tag. Those are Class C misdemeanors. Now, if you fail to pay the fine, or if your fine was converted to community service and you fail to perform the community service, then the court can issue what is called a capias pro fine. What that means is a warrant for your arrest. And the court issues a capias pro fine. You either have to pay the fine. If you do not pay the fine, then you would have to sit your fine out in jail. You have to serve time out in jail to pay off your fine. You will receive $100 credit for every 1 day that you spend in the jail. Okay, now the next highest misdemeanor is a Class B misdemeanor. With the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, or a fine that does not exceed $2,000, or you could be given both such confinement and a fine. Now, the highest misdemeanor is a Class A misdemeanor. With the Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year, in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation. Unadjudicated. We normally refer to as deferred probation. Unadjudicated probation. And the other type of probation is called adjudicated probation. The difference between the two is as follows. With unadjudicated probation, you do not have a conviction on your record. And if you successfully complete the probation, the case will be dismissed and you may qualify for a non-disclosure. A non-disclosure basically means that your record will be sealed to the general public. So the general public cannot have access to it. Now, the operative word that I've used was general public. Now, the general public cannot have access to it, but the government can. Okay, so most of the public is the general public, so most of the public cannot have access to it. Now, the next type of probation is called adjudicated probation. We normally refer to it as regular probation. With regular probation or adjudicated probation, it will result in a conviction on your record. However, there is something that is called judicial clemency. What that means is the judge can set your conviction aside and you will no longer have a conviction for this case on your record. Now, in order to qualify, three things have to happen. You have to successfully complete the probation. There cannot be any more time left on the probation. And you have to be successfully discharged, which means to be let off of probation by the probation department. If those three things happen, then the court can set your conviction aside. You will no longer have a conviction for this case on your record. However, if you get a subsequent conviction, or if you get a conviction later on for another case, then the case that you receive judicial clemency on can be brought back up. It can be resurrected, brought back up, and used against you. And if you try to get a license with Child Protective Services or CPS, they can suspend your license, or if you have a license, they can revoke or suspend that license. So if you're trying to get a license, they can deny giving you a license. That's what I was intending on saying. Now, everyone in here who, for a case, you should have a clipboard. Okay, make sure you have a clipboard. I'm going to go over the paperwork that's contained on the clipboard. The first document should be judge's explanation of rights to defendants without attorney. The document looks like this. Now, everyone that's here will read and sign this document. I'm going to go over this document with you. And it starts off by saying that as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you cannot afford to hire an attorney, you may request or ask that an attorney be appointed to represent you. And number three, you may represent yourself. That is, if you do not want a lawyer to represent you, you have a right to represent yourself. Now, the first paragraph below number 3 says, if you want an attorney, you have enough money to hire an attorney, your case will be reset to give you time to hire an attorney. What that means is, reset means you'll be given another court date from today to give you time to hire your attorney. The next paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney or ask that an attorney be appointed to represent you. by the court, but you must first fill out a financial questionnaire. Now, the financial questionnaire is also on that clipboard. It is a 3-page document that is titled Judge's Explanation, that is titled Jefferson County Affidavit of Indigence. And we need everyone to turn to that document. That document looks like this. Now, this is only for people who will be requesting a court-appointed attorney. If you're not requesting a court-appointed attorney, you don't need to worry about this document. If you're requesting a court-appointed attorney, you will have to fill out this first page. And then everybody turn to the second page of this document. On the second page, you have to fill out the top portion that is titled Defendant's Oath, and you have to fill out this middle portion that is titled Unsworn Declaration by Defendant. Once you finish filling out the first page and these 2 sections on the second page, then you will stop. Okay? All right. Now let's go back to that first document, Judge's Explanation. The next paragraph states that you may not speak to the prosecutor about your case unless you first sign a written waiver of your right to be represented by attorney. Now, this is only for people who will be representing themselves. If you're not representing yourself, you don't have to worry about this. Now, if you are representing yourself, that is, you're waiving your right to have an attorney, then you would have to fill out this document. It's also on the clipboard. That's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. This is only for people who will be representing themselves. If you're not representing yourself, if you are requesting a court-appointed attorney, or if you're requesting requesting time to hire an attorney, you don't have to sign it. So you don't even have to worry about it. All right. Now, if we go back to the first document, and it says that if you want an attorney, that you may not speak to the prosecutor. Now, the prosecutor, these are prosecutors. They are assistant district attorneys and work for the Jefferson County District Attorney's Office. If you are representing yourself, that means you are your own lawyer. And if you are your own lawyer, then you will have an opportunity to talk to one of the 2 prosecutors. All right? And because you're your own lawyer, just like if you had a lawyer, your lawyer would talk to them. Because you are your own lawyer representing yourself, you can talk to them. That's only for people who will be representing themselves. If you're requesting a court-appointed attorney, if you want to hire an attorney, you won't be able to talk to them. All right. Now, for those individuals who will be representing themselves, the next to the last paragraph is in block, states, be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. And the last paragraph, or the last 1-sentence paragraph, states that if you are representing yourself, you may change your mind. That is, say, well, I changed my mind, I don't want to represent myself. You may change your mind at any time and request that an attorney be appointed to represent you. All right. Now, at the bottom of that document in bold letters, it states defendant's choice. Mark initials next to only one choice. Now, everybody's going to make a choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left of this document. If your choice is to hire your own attorney, you're going to place your initials on the first line to the left. Sign it at the bottom and stop. Okay. If your choice is to apply for a court-appointed attorney, then you will place your initials on the third line to the left, okay? If your choice is to apply for a court-appointed attorney, put your initials on the third line, sign it, and date it. Now, if you are waiving your right to an attorney or giving up your right to have an attorney, you would like to represent yourself, then you will place your initials on the fifth line, which is the bottom line to the left, and then you will sign and date. And just for a brief recap, everyone is going to sign this document. You're either going to sign it as hiring an attorney, applying for a court-appointed attorney, or representing yourself. Then, for those individuals who will be requesting a court-appointed attorney, you would have to fill out the first page of this document that's titled Jefferson County Affidavit of Indigence. And on the second page, you would have to fill out the top portion that's titled Defendant's Oath and the middle portion that's titled Unsworn Declaration by Defendant. Now, for individuals who will be giving up their right to have an attorney, they would like to represent themselves. They would have to sign this document on the fifth line, initials, and then sign it, and then the fifth line, and then you would have to read and sign this document as titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Okay. Do we have any questions? Anybody have any questions? Okay. Now, you can stop doing that right now because we're going to give you time to finish filling out those documents. As a defendant in a criminal case, you also have a right to have a trial by jury. What that means is this. The area over there, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as the jurors in your case. Okay? And that just simply means that they will listen to the evidence that's being presented. They will listen to the arguments that the attorneys for both sides present. They will go back into the jury room to deliberate, and then they will decide to find you either not guilty or guilty of your charge. You also have a right to waive or give up your right to have a jury trial. Waiving your right to have a jury trial means that you're giving up your right to have a jury trial, which means you don't want to have a jury trial. If you waive or give up your right to have a jury trial, then your case will come before the court in one of 3 ways. One way it can come before the court is by way of what we call a bench trial. And what a bench trial is a trial by judge only. The judge will be the judge and the jury in the case. The judge will listen to the evidence, listen to the arguments of both sides, and then the judge will apply the facts to the law, and then the judge will decide to find you either guilty or not guilty. All right. You also, the other way that your case can come to, you also have a right to waive your right to have a bench trial. This means you don't have a bench trial. So if you waive your right to have a jury trial or a bench trial, what you're saying is this here. I'm entering a plea of either guilty or no contest. You have a right to do that. Now, there are 3 types of pleas. Person can say, well, I did it, so I entered a plea of guilty. Or I don't want to fight the charges, so I'm going to enter a plea of no contest. Or I didn't do it, so I was to enter a plea of not guilty and I want a trial. Okay? So, but if you enter a plea of guilty or no contest, your case will come before the judge by way of a plea bargain. It can be an agreement. What a plea bargain is, it's an agreement that you have worked out with the state or the defense or the prosecutors to settle your case. For example, let's say you spent 2 days in jail and the state is offering you to serve 2 days in jail. That simply means, and you say, okay, I'll take that deal. That's it, so y'all have an agreement. Okay, or let's say the state is offering you probation. And you say, well, I like that, I'll take the deal. That's an agreed plea bargain agreement. Now, if you work out an agreement with the district attorney's office, or with the prosecutors, or with the state, then your case comes before the judge. And then the judge can do one or two things. The judge can accept the agreement or reject the agreement. If the judge rejects your agreement, which means the judge said, I'm not gonna go along with that, then you have a right to take back your plea of guilty and no contest. You can say, well, judge, since you are not going along with the plea bargain agreement, I take back my plea. You have a right to do that. All right. Now, if the judge does go along with the plea bargain agreement, and if you decide within 30 days that you would like to appeal your case, you have to get permission from the judge. And if the judge gives you permission, then your case is going to leave this court. It's going to go to another court. It's going to go to the upstairs to the Ninth Court of Appeals. There are 4 judges up there who will review your case. And they can, if they can do one or two things, they can either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, case over. Or they can send the case back down to this court and on this court to give you a whole new trial. Now, if they deny your appeal, then you can appeal it to a higher court than them. You can appeal it to the Texas Court of Criminal Appeals, which is located in Austin, Texas. It is the highest criminal court in the state of Texas. You would have to file what is called a pro se petition for discretionary review. What that means is this. Pro se means you're on your own, you're representing yourself. So you're representing yourself and you're asking the court to, you're petitioning the court to review your case, to see whether or not your appeal should have been granted, or whether or not this court wrongfully convicted you or committed an error by convicting you. They can do one of two things. They can either grant or deny your pro se petition. If they grant your petition, they can simply find you not guilty. Or they can, or if they deny your petition, well, or they can send the case back to the Ninth Court of Appeals with orders and send it back down here with orders. All right. Now, if they deny your petition, then at that point, your conviction will stand. All right. Now, you also have a right to have witnesses that come to court. That chair right there with the microphone in front of it, we call it the witness stand. And what witnesses do, they come into court and testify. They can testify for you or against you. You represent yourself, if you have a lawyer, you can ask some questions. You represent yourself, your lawyer can ask some questions if you have an attorney. That's called either direct examination or cross-examination. Now, you can waive or give up your right to ask them questions as well. Or you can waive or give up the right to call witnesses. If you do that, that simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. Now, you also have what we call a Fifth Amendment right against self-incrimination. I know sometimes we watch television shows like Law and Order, and you might see a lawyer, a television lawyer, asking a witness on the witness stand, trying to ask a question. The person says, I take the fifth. What that means is they're exercising their Fifth Amendment right to not say anything. The law gives everyone a Fifth Amendment right against self-incrimination. You don't have to testify. The state can't force you to testify. The government can't force you to testify. District attorney can't force you to testify. Why? It's simple. They have the burden to prove that you're guilty. You don't have to prove yourself guilty. Okay? You don't have to get up there and say, I did this. No. You can just remain, if you can exercise your right to remain silent, that's your right. All right. Now, you can waive or give up your right. That means you have a right to take the witness stand if you waive or give up your right, and you'll take the witness stand and testify. Okay. Now, you also have a right to have discovery. Discovery is you have a right to see the evidence that the state has in its file. You have a right to see witness statements, your statements, lab reports, police reports, photos. You have a right to see video recordings, listen to audio recordings, see documents and instruments, whatever they have that they're gonna be using against you in their file. You have a right to have access to that. That's called discovery. Now you can waive or give up your right, which means if you waive or give up your right, you're saying, I don't want to see that evidence. I don't want to have access to it. All right. Now, everyone that's here today, you have a charge has been placed on you, you've been arrested, you've been placed in jail, you're out of jail on bond, you're either out of jail on a cash bond, which means you pay the full amount of the bond to get out of jail, you're out of jail on a surety bond, which means you pay a bondsman a percentage of the bond to get out of jail, or you're out of jail on a PR bond or personal recognizance bond, which means that you didn't have to pay any money to get out of jail. You was released under your own personal recognizance. Now, the reason why I brought that up is because you should be aware that every day that you spent in jail, it can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail, and let's say you're in a state that worked out a plea bargain agreement for you to serve 5 days in jail. You don't have to serve 5 days in jail. Why? Because you've already served 5 days in jail. Therefore, you're going to be given credit for the time that you've already served. Excuse me. Now, if you serve 5 days in jail and they offer 7, that means you have to serve 2 because you already served 5. You're going to get credit for the 5. Now, every day that you spent in jail also is credited as $100 a day toward your fine and court costs. So if you spent 5 days in jail, that's $500 that can go toward your fine and court costs. So if the state is offering fine and court costs of $500, that means you don't have to pay it because the time you spent in jail has already paid it. Therefore, it will be taxed every time. Now, if the state is offering fine and court costs of $700, that simply means that you would have to pay $200, and you'll be required to pay it on the day that your case is disposed of. If you can't pay it, no problem, because we can put you on a payment plan where you can pay off the $200 in small monthly installments until it's paid off. Now, if you do not have a job or income, no problem, because we can convert your fine and court costs to community service. And for every 1 hour of community service that you perform at a nonprofit organization in Jefferson County, you will receive $12.50 that will go toward the payment of your fine and court costs. So $12.50 if you work an 8-hour day, that's $100. So in our scenario, you work 2 8-hour days, that's $200 is over. You paid your fine and court costs. All right. Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program for people who have not been in trouble. If this is your first time getting into trouble, Jefferson County, when I say Jefferson, I'm talking about the district attorney's office. They have a program that's called pretrial diversion. With that program, they will dismiss your case, and you can get it wiped off your criminal record. The way it works is as follows. It has to be your first time getting into trouble. You have to have an attorney to help you get in the program, and it cannot be for an offense involving unlawful carrying a weapon or resisting arrest. Get into the program, they dismiss your case, you complete the program, you can get it expunged, which means erased, deleted, or wiped off from your criminal record, like it never happened. All right. Now, if you are a veteran of any one of the branches of the United States military, the district attorney's office has another program that is called Veterans Court. It is for veterans only. With that program, you get into the program and complete the program, they will dismiss the case. And then you can get what is called a non-disclosure that I mentioned to you earlier, where your record is sealed to the general public. Okay? Now, in order to qualify for that, you just have to be a veteran of any one of the branches of the United States military. This court, County Court at Law number 2 of Jefferson County, Texas, has a program that God led me to start in March of 2017, within the first 100 days of me taking office. The program is called the Community Safety Initiative. We normally refer to it as the CSI program. With that program, we have partnerships with various agencies in our community. One of the agencies that we have in our community is Spindletop. Spindletop is our local mental and health agency in our Southeast Texas region. And what Spindletop will do, they will do a private interview. Then they can do an assessment to determine what your mental health needs are. And they can develop a treatment plan to address your mental health needs. Now, you do not have to be incompetent or insane to participate in the program. You can merely suffer from anxiety or depression or any other host of mental illnesses. And Spindletop has the expertise to address your mental health needs. Now, if you have problems with drugs and alcohol, well, Spindletop has a program that addresses drug and alcohol issues. The program is called ATAR. ATAR stands for, it's an acronym that stands for Addiction, Treatment, and Recovery. We also have a partnership with our local drug and alcohol council that has a program to address drug and alcohol addiction that is called OSAR, OSAR, and that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And with those programs, they will do a screening, an assessment, and they would develop a treatment plan for either outpatient and inpatient treatment. If you are unemployed, or if you're looking for a better job, then we have a partnership with our local group that is called the Golden Triangle Empowerment Center. They have a partnership with Lamar University, and Lamar University has a program that's called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas, they will help you to get a job in the area that you're trained in. And if you have not graduated from high school, or you do not have a GED, they have a GED program which you can receive your graduate equivalency diploma. Now, all of those programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we do not just give time, we take out time. And that simply means that we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people have too much to lose. So I like to say that when you come to County Court at Law number 2 of Jefferson County, Texas, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know and we will direct you to the people or the person that you need to talk to. Now, at this time, we're going to give you an opportunity to finish filling out the paperwork. If you need help filling out the paperwork, just simply raise your hand. Let us know, and myself and other members of the court personnel will be happy to assist you at filling out the paperwork. Now, the court is going to go into recess to give you time to do this. It's going to take a few minutes for you to fill out the paperwork. If you need to use the restrooms, there are two restrooms that's right out in the hallway. They have the men's restroom, which is in front of County Court Law number 3, which is next door to us. And the women's restroom is on the opposite side of the hall in front of the 172nd District Court. You'll be allowed to use one of those restrooms so that you can you'll be allowed to use the restroom. And as I mentioned to you earlier, we'll give you time to finish filling out the paperwork. Now, at this time, we have some folks from Family Services. We have Johnny, who is here. He's going to come and tell you a little bit more about a program for individuals who have cases involving family violence, assault or family violence. How you can get your case dismissed and how you can get it expunged and wiped off your record. Okay? So at this time, we'll talk to Johnny.
Okay. Thank you, Judge.
You're welcome.
Good morning. I'm Johnny Stewart. I'm with Family Services of Southeast Texas. You may know us from the Women's and Children's Shelter. We also have other programs. And this program is called the Batteries Intervention and Prevention Program. It used to be called the Domestic Violence Prevention Program. This program is part of the pretrial diversion, and it helps those individuals who have been charged with a family violence charge to be able to take this program. And once you complete it, then that case will be taken care of. But you'll have to complete 18 weeks, and it's 2 hours per session. We've been doing this for quite a while. We're getting ready to have our 100th year anniversary. So this program is very successful. So if you have an opportunity to take this program, go ahead and take that opportunity. It's not going to only help you, it's going to help your family. And I have brought Shamika, she's not going to speak, but she also has programs for the free of service for victims of domestic violence. So if you know maybe your partner, or if you know anybody who has been involved in domestic violence who needs services, we also need some of that information. That's a totally free service. So take advantage of this, if you've been involved in domestic violence. Even if you're not charged with it, you think you might need some help in your relationship, take advantage of this. I appreciate it. Thank you, Judge.
Okay, you're welcome. Okay, ladies and gentlemen, as I mentioned to you earlier, the court is going to go into break so that we can give you time to finish filling out the paperwork. If you need help, just raise your hand. Okay, and what we'll do, we'll help you. At this time, now, make sure that you conduct yourself accordingly. And as I mentioned to you earlier, we're still in court. And the other thing is you'll be allowed to go use the restroom. Please do not leave the courthouse. If you leave the courthouse and your name is called and you're not here, guess what? Your bond gonna be forfeited and a warrant is gonna be issued for your arrest. And guess what? You'll be arrested, bond out of jail at some point, and guess what? We got to go through all of this here all over again. Okay? And so do not leave the courthouse. All right. So at this time, we're going to go into recess. And as I mentioned to you earlier, if you need some help with your paperwork, let us know. If you're finished with your paperwork, you can raise your hand and let us know as well. And then we'll pick up your paperwork. And then once we do that, we're going to call you up one at a time before the bench. We're going to put you in one or three categories. One is you want to hire. 2, you want to apply for court-appointed attorney. Or 3, you want to represent yourself. And then we'll take it from there. Okay? So at this time, the court will be in recess. Jefferson County Court Law number 2 is back in session with the arraignment docket. First case is cause number 25 CCCR 066, excuse me, 0688. Case is style of state of Texas versus Aurelia Ramirez. Okay, Ms. Ramirez is, she speaks Spanish, and so we have our interpreter, Ms. Jennifer Raji. Mr. Raji, would you please raise your right hand? Mr. Raji, do you swear to interpret Spanish to English and English to Spanish to help you God?
Yes, Judge.
You may put your hand down. And how are you doing, Mr. Raji?
Good, Judge. Thank you for asking yourself.
I'm doing fine, thanks for asking. Now, Mr. Raji, ask Ms. Ramirez if her full name is Aurelia Ramirez.
Tu nombre completo es
Aurelia.
Aurelia
Sí.
Ramírez.
Okay,
Yes.
ask her to raise her right hand.
Levanta la mano derecha.
Okay, Ms. Ramirez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
¿No vas a decir la verdad, toda la verdad, ante Dios?
Okay,
Yes.
you may put your hand down. How are you doing?
¿Cómo está?
Bien.
Good.
Good, that's good. Now, Ms. Ramirez, I have 2 documents before me. And the first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
¿Tú eres el verdadero?
Is this your signature on the line, is that a
Yes.
defendant?
Yes.
And are these your initials on the
Yes.
line that state you like to apply for court-appointed attorney?
Yes.
Ok.
That's it.
Entonces, ¿usted entiende lo que está hablando?
Sí, ahorita es lo de las iniciales para poder solicitar un abogado, ¿no? Lo de los.
Sí.
Yes.
Okay,
Yes,
also,
Judge.
so I have a document that is titled, well, this is Jefferson County Affidavit of Indigenous. Ask if she recognizes this document.
¿Puedes dar el documento? Yes.
Okay, on page 2 of this document, there's a signature above the line that's titled defendant signature, except this is her signature.
¿Esa es su firma ahí?
Sí.
Yes,
Okay.
Judge.
Now, you can ask her, before she signed and initial these documents, did Mr. Raji go over these documents with you in Spanish?
Antes de firmar todo ese documento, ¿sí te explicó todo en español?
Ya me explicó ahorita, sí.
Yes, Judge.
Sí.
And did you understand everything that she went over?
Y usted entendí todo antes de firmarlo.
Sí.
Yes, Judge.
And is everything in these documents true and correct to the best of your knowledge?
Y todo es de verdad lo que firmaron.
Sí.
Yes, Judge.
Okay. Ms. Ramirez, I read your answers. You meet the eligibility requirements for the appointment of court-appointed attorney. An attorney that's appointed to represent you is Attorney Charles Wallace.
Es que se leo todo los papeles y le van a apuntar un abogado, se llama Charlie Rowe.
Ujú.
She's gonna reset your case.
Y la van a cambiar la cita de corte y le van a dar la información de un abogado y no.
Me van a dar otro corte. Sí. Ok, está bien. Está bien.
You stand over there and get her
Thank you.
reset, and she's free to go.
Gracias.
Tell her, have a blessed day. Oh, let's see. Eduardo Cortez. Okay, case. Court has 2 cases, cause number 25 CCCR 0750 and cause number 25 CCCR 0752. Both cases are style of state of Texas versus Eduardo Cortez. Ask Mr. Cortez if that's his full name.
Yes,
Yes.
Okay, Mr. Cortez, would you please raise your right hand? Okay, Mr. Cortez, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God?
¿Vas a traer la verdad en beneficio de Dios?
Sí.
Okay,
Okay,
Yes.
so then he can put his hand up.
pues bajar.
Mr. Cortez, how are you doing?
Yeah.
Good.
Good, all right.
Okay. Okay.
Okay, Mr. Cortez, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document,
¿Recuerdas ese documento que firmaste?
Sí.
Yes,
and are these your initials online that state you'd like to apply for court-appointed attorney?
y esas sus iniciales diciendo que quieres aplicar para un abogado?
Sí.
Yes, Judge.
Also, I have another document that's titled Affidavit of Indigence. And so if you recognize this document,
¿Recuerdas ese documento también?
Sí.
Yes, Judge.
and on page 2 of this document, there's a signature above the line that's titled Defendant Signature. Ask me if this is his signature.
¿Y esa es su firma ahí completo?
Sí.
Yes, Judge.
Now, Mr. Cortez, need to ask you some questions about your affidavit of indigence.
Dice que
Check
tiene que
this out.
presentar unas, darle tiempo para traer los cheques para que lo enseñe lo que usted gana, o que si usted quiere agarrar el abogado.
No, quiero agarrar el abogado, no quiero que termine.
Okay, he said he's just gonna get his own attorney, and then that way he can be done with the case.
Okay, he needs to, make his change on this here.
Entonces, vas a poner en línea aquí y vas a poner las iniciales aquí.
En la parte de arriba.
Ese es para que usted lo ayude a agarrar su abogado.
Okay. His case is gonna be reset to give him opportunity to, well, let me ask him to raise his hand. Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Now, is everything in this document that's titled judge's explanation of rights to defendants, without attorney true and correct to the best of your knowledge?
Sí, todo.
Sí.
Yes, yes.
Okay. Tell him he can get his reset.
Te la van a dar la cita y tienes que agarrar un abogado antes de la cita de traerlo con usted. ¿Ok? Ahí lo vamos a hacer.
There you go. Joseph Vera? Mr. Vera, you can raise your right hand. Mr. Vera, do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Vera, you may put your hand down. How you doing, Mr. Vera?
I'm doing okay.
That's good. Mr. Vera, I have before me a document that is titled, well, actually, it's two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorneys. You recognize this document?
Yes, sir.
So it's your signature on the line that's titled Defendant,
Yes, sir.
but is your initial on the line that states you'd like to waive your right to an attorney and represent yourself?
Yes.
I also have another document that is titled Waiver of Counsel Purposes of Entering Guilty Plea of Proceeding to Trial. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir. Correct.
Okay, Mr. Vera, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Vera, I read your answers. See here that you like to waive, you have talked to the prosecutor, is that correct?
Yes, sir.
Yes,
Is that
Your Honor.
correct?
We would ask that this case be reset to Friday. It's going to be a plea. I believe Mr. Vera needed some time to get the money together.
Okay, so we're gonna reset this case to this coming Friday.
Yes, Your Honor. Your Honor, if we could know what the court cost amount would be.
Let's see, this is, do we have, somebody who can calculate? It's gonna be his court cost. What is
It's an
the,
appeal for Class C
it's a speeding appeal.
It'll be about 277.
That's the court cost. What is the fine?
The fine will be on
It says $377, so you're gonna bring about $400.
yes, sir. It'll have to be cash or check.
It could, huh?
$10 or.
Well, 77 would be 87. I told him bring 400.
Yeah.
That'll be a little bit more.
400, it'll be good.
Yeah, you can put it on your card.
Okay.
You
I
can,
get paid tomorrow. I mean, if all I need to do is pay it and then bring out a receipt or whatever, so I don't have to waste no time Friday or however.
oh, you can come, you wanna come in tomorrow?
Yes, I get paid tomorrow. Well, I work days. I'm off. I got days, Wednesday, Thursday, and I'll be off Friday.
So what day you wanna come in?
Friday to pay it.
Okay,
And bring out the receipt of it.
yeah, once you come in, we'll take care of it and then you'll go downstairs, get a receipt and bring it back up here.
come back up?
You'll have to come. up
Friday.
here. They'll have to have the judgment stuff to bring down there, so they'll know what.
Okay, so we're gonna reset his case to Friday, and that's the 21st. What? It's Friday.
Yeah, thank you.
24th. Okay, okay, Mr. Vera,
Thank you, sir.
stand in front and get your reset. Joseph Vera is on page, well, I have no numbers on these pages. Okay. Omar Young. Mr. Young, would you, your full name is Omar Young?
Senior.
Senior, Mr. Young, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Young, you may put your hand down. How you doing, Mr. Young? That's good. And Mr. Young, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line? It's titled Defendant?
Yes, sir.
And are these your initial online states you'd like to apply for court appointed attorney? I have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Young, before you signed and initialed these documents, did you read the documents? Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Hey, Mr. Young, I read your answers. Based on your answers, you do not meet the eligibility requirements for the appointment of court-appointed attorney. So at this time, you have two other options. You can either request that this case be reset, give you time to talk to an attorney, see if you can hire an attorney, or you can waive your right to an attorney and represent yourself.
I have to reset, see if I can find an attorney.
Okay, Ms. Mosby,
Yes, sir.
you'd like to change this to reset the hire the own attorney?
You know, what is it, because I make too much or what?
Yeah, what we do is look at the income and your expenses. And based on this, you have some money is left over that should be give you enough time to hire based on that. All right, now is everything in this document true and correct to the best of your knowledge?
Yes,
Is it? Okay, okay. And your case is going to be reset, give you an opportunity to hire an attorney. You're gonna sit and have a seat in that chair, wait for your name to be called. Once your name is called, you go to the window where your name is called. She'll reset your case. Once your case is reset, you're free to go in your place state.
All right.
Ardesia May. Miss May. Your full name is Ardesia. Is that Abril?
Gabriel.
Abril May?
Yes.
Miss May, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Miss May, you may put your hand down. How are you doing, Miss May?
I'm done.
That's good. Miss May, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Are these your initials on the line
Mhm.
that state you'd like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes.
On page 2 of this document, there is a signature above the line that is titled Defendant Signature. Is this your signature?
Yes.
Ms. May, before you signed and initialed these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Mhm. Yes.
Ms. May, I read your answers. Based on your answers, you meet the eligibility to requirements. Oh, they can put a number on there. For the appointment of a court-appointed attorney. And the attorney who has represented you, who has been appointed to represent you in these cases is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you.
Yeah.
You will be given information to contact him. Our court coordinator will give you that information. But before she gives you that information, I need to give you some bond conditions. Ms. May, will you please step to the side so I can give you these bond conditions?
Mhm.
Okay, you can stand back in front of the bench. Now, Ms. May, I just handed you a document that is titled Standard Bond Conditions in County Code Law Number 2.
Mhm.
I'm going to go over this document with you, and it states as follows. Following the return of a criminal information in County Code Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and a test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes.
And condition number 3 states the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes.
Condition number 4 does not apply. However, condition number 5 does apply. Condition number 5 states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that? All right. Now, Ms. May, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yeah.
Now, please have a seat in that first chair on the wall. Wait for your name to be called. Once your name is called, you go to the window where your name is called. And then once you finish it, when you're free to go, and you have a blessed day. All right, thank you. Xavier Harris. Harris. This is cause number 25 CCCR 0880. Case of Style the City of Texas versus Xavier Isaiah Harris. Mr. Harris, is that your full name? Mr. Harris, would you please raise your right hand? Mr. Harris, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Harris, you may put your hand down. How are you doing, Mr. Harris? I'm doing fine. Thanks for asking, Mr. Harris. I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant? Or are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature? Mr. Harris, before you signed and initialed this document, did you read the document? Did you understand what you read? You didn't understand what you read?
Yeah.
I'm just asking you a question. Okay, because the reason why I'm asking you the question is because they have all of this stuff filled out. It asks questions and you filled it out.
Oh, yeah.
Did you understand that?
Yes, sir.
And this information here that's filled out, did you understand this?
Yes, sir.
The information down here that you fill out, did you understand that? Okay, now, on this document, it has a signature and a set of initials. Did you understand this? And did you understand this portion?
Yes, sir.
Okay, so what did you not understand? Hmm?
No, sir.
Oh, okay, so you understood what you signed in the initial, all right. Now, is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, now, Mr. Harris, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you in this case is Attorney David Grove. Attorney Grove will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once you get the information, you're free to go and you have a blessed day.
Yes.
Please have a seat in the first chair on the wall. Rashad Wiltz. Mr. Wiltz, your full name is Rashad J. Wiltz. Mr. Wiltz, would you please raise your right hand? Mr. Wiltz, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Wiltz, you may put your hand down. How are you doing, Mr. Wiltz?
Good.
You doing good? Okay, Mr. Wiltz, I have 3 cases before me, and I also have 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you would like to apply for court-appointed attorney? You have to speak up.
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And on page 2 of this same document, there is a signature. One of them is above and next to the word that is titled Defender Signature. Is this your signature?
Yes.
Mr. Wilkes, before you signed and initialed these documents that I just showed you, did you read the document?
Yes.
Did you understand what you read? Was everything in these documents true and correct to the best of your knowledge? Okay, Mr. Wilkes, I read your answers. Based on your answers, you meet the eligibility. That door is locked. You meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Jennifer DeLodge. Attorney DeLodge will be given information to contact you. You also be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you will be free to go, and you have a blessed day. Please stay, have a seat in that first chair on the wall. Tyrone Wilson. Mr. Wilson. Your full name is Tyrone Dwayne Wilson.
Yes, sir.
Ms. Wilson, would you please raise your right hand? Ms. Wilson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Wilson, you may put your hand down. How you doing, Mr. Wilson?
I'm doing good.
That's good, Mr. Wilson. I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that's state you like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes.
And on page 2 of the same document, there's a signature above the line that is titled Defender Signature. Is this your signature?
Yes.
Okay. And Mr. Wilson, before you sign and initial these documents, did you read the document?
Yes,
Did you understand what you read?
yes.
And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Wilson, I read your answers. Based on your answers, meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information before she gives you, before she gives you that information, you can have a seat in the chair and wait for your name to be called. Are you ready? Oh, you have to bring him back up too when we finish. Hey, Mr. Wilson, you come on back up. Now, Mr. Wilson, I have some bond conditions that we need to give to you. And the bailiff is going to hand you these bond conditions. Ms. Bailey? Would you hand these? That's showing who your court-appointed attorney is,
Yeah, that's what we said here.
okay?
They don't have no other charge, this is the only charge right here?
Yes, I see one charge. Hold on. There's only one charge.
Thank you.
Okay, now, Mr. Wilson, the bailiff just handed you a document that is titled Standard Bond Conditions in County Court Law Number 2. Do you see that title?
Yes, sir.
Okay, I'm going to go over this document with you, and it states as follows. Following the return of a criminal information in County Court Law Number 2, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, the other state, or of the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes.
Now, condition number 3 and condition 4 does not apply. However, condition number 5 on the next page does apply, and condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
That's like a security guard type deal.
No, that's like the bailiffs, okay? And the police officers. All right. Now, do you understand that condition? Now, if you violate any one of these conditions, your bond can be revoked. If your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Okay.
Okay, you already gave him his reset? Okay, those bond conditions that you have in your hand is for your records. You're free to go. You have a blessed day.
Okay, y'all too, thank you.
You are. Did Mr. Hilton, do we have you had a paperwork on Khalil Malik Bradley Harris?
Sent over.
Yeah, I got it. It's on here.
Oh.
Okay. Huh?
Oh, that was on Christmas? Yeah. Yes, but- Oh, Haley's calling.
Oh, she is on.
You got a point on something, huh? You got appointed on, Khalil. Didn't you get appointed on Khalil Malik Bradley Harris?
That's the one that's on the plea. That should get rid of the plea.
Oh, you say he got appointed on who?
Xavier Harris.
Xavier Harris. Hold on a minute. Make sure I got it. Okay, Xavier Harris. Let's see. You have his waiver. North Carolina Code Law number 2 is back in session. Court is in session and calls number 25 CCCR 0430. Case is style of the state of Texas versus Khalil Malik Bradley Harris. Mr. Bradley Harris, is that your full name? Mr. Harris, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. Mr. Bradley Harris, how are you doing? That's good, Mr. Bradley Harris. You represent, well, you're representing yourself in this case. State is represented by Attorney Shane Hilton. Attorney Hilton, how are you doing?
I'm good, Your Honor. Thank you.
That's good. I'm Mr. Bradley Harris. I have before me 2 documents. The first document is titled Judicial Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line titled Defendant? Are these your initials on the line that state you'd like to waive your right to an attorney and represent yourself? Yeah. Also have before me a document that is titled Waiver of Counsel for Purpose of Entering a Guilty Plea or Proceeding to Trial. You recognize this document? Is this your signature on the line that's titled Defendant? Mr. Bradley Harris, before you signed and initialed these documents, did you read the documents? Yeah. You understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay. Mr. Bradley Harris, I also have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Khalil Malik Bradley Harris, on or about June 16th of 2024, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Bradley Harris, do you understand what you've been charged with?
Yeah.
And to this charge, how do you plead? Guilty, not guilty, no contest? Now, you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charge? Mr. Bradley Harris, I also have before me a document that is titled Misdemeanor Plea Admonishment. Do you recognize this document?
Yeah.
On page 2 of the same document, there are 2 sets of initials. The first set of initials is below a paragraph that's titled waiver, and is on a line next to a box that's checked nola contendere, which means no contest. Did you place your initials on this document?
Yeah.
The second set of initials is below a paragraph that is titled discovery admonishment, and it is on a line next to a statement that reads, I do not wish to have discovery. I waive my right to discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document as well?
Yeah.
On page 3 of the same document, there's a signature above the line that's titled defendant signature, just your signature.
Yes, sir.
On the next document that's titled trial court certification of defendant's right of appeal, you recognize this document.
Yeah.
And at the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? And is this your signature on this document? Now, Mr. Bradley Harris, before you signed and initialed all of these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Bradley Harris, I read your answers. Now, Mr. Bradley Harris, are you a citizen of the United States?
Yeah.
State? Yeah.
State office, state, just give it 1, Your Honor.
Okay, no objections. State's exhibit number 1 will be admitted. And Mr. Bradley Harris, the state is offering state's exhibit number 1 to be used as evidence against you. Let me go again. State's exhibit number 1 is the first document that you signed on this tablet. It is also the same document that have your initials in these 2 locations, and it has your signature on page 3. Is it all right for the state to use this document as evidence in your case? Okay. No objections. State's exhibit number 1 will be admitted. Mr. Bradley Harris, is there any evidence that you are currently mentally incompetent to stand trial? Is there any evidence that you're mentally ill, you don't understand what's going on? Okay. Now, Mr. Bradley Harris, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
Your Honor, we'd ask the court for 45 days in the county jail, and we'd ask that be given credit for time he has served of 45 days, and we'd ask that the court costs in this matter be taxed and retired.
Okay, Mr. Bradley Harris, the state is offering that you serve 45 days in Jefferson County Jail. You have already served 45 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. That means you would not have to serve any more time in jail on this case. The court costs in this case would be taxed and retired. What that simply means is that you would not have to pay the court costs because the time that you spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Bradley Harris, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Okay, Mr. Bradley Harris, I will follow the plea bargaining agreement that you have entered into with the state. Mr. Bradley Harris, you're gonna stand next to the bailiff. Follow her directions. Once you're finished following her directions, you'll be free to go and you have a blessed day. Let's go. Okay. Now we have, select the young lady in the back. What's her name? Baby, she, okay, Tarika Tennille Burnett. Ms. Burnett, your full name is Tarika Tennille Burnett,
Yes,
is that correct?
yes, sir.
How you doing, Ms. Burnett?
I'm all right. How you doing?
I'm doing fine, thanks for asking, Ms. Burnett. You represented this case by your attorney, Attorney Peter Dahl. Mr. Dahl, how are you doing?
Very good.
Okay, and the state is represented in this case by Attorney Haley Simmons. Ms. Simmons, how are you doing?
I'm great, Judge. How are you?
Okay, now what are we doing in this case?
Your Honor, this is Mr. Hubel's case. I'm standing in on his behalf. There was restitution that was ordered in this case. The defendant does and has in fact given the money orders to Mr. Doyle. However, Andrew did inform defense counsel at its last setting, and I'm not sure if it was related to the client, that the money orders are in incorrect format. It is two separate cases. They needed to be separated. At this time, the money orders that Mr. Doyle has brought to court today are still the same money orders that were told were incorrect at the last setting, and they were never amended or changed or.
What's wrong with the money orders?
Your Honor, this is two separate theft cases. The restitution is to go to two different institutions, and the way the money orders have been specified, I'm sorry, it's the total amount, but it's incorrect in the sense that they have not been separated for each cost for each institution. This was brought to Mr. Doyle's attention.
Okay, when you say they weren't separated for each institution,
Correct, Your Honor.
what do you mean?
So, trying to explain it real quick, it's 1327 right here, but it's two separate theft cases. There's restitution in one amount for one case and restitution another amount for the other. And I can't separate the restitution between the two money orders, if that makes sense.
So she have a total amount,
There's a total amount.
but for the
which is here.
for the two money orders, you understand what we're saying?
I understand what she's saying. She said it's supposed to be two, like one store gets 7 and the other one get 5, but I wasn't aware.
And if I may, Mr. Hubel did make that aware to Mr. Doyle in its last setting in terms
So,
of how
so what do we need to do? Just give her,
the correct amounts and how they need to be separated so she can go.
and
make
then
those
she can
money
go to the
orders.
store to
She'll
see if
probably
you
have to
can,
cash these out and then redo them.
Can I cash on
They should let her.
you might go cash them at the same place you got them.
And then have-
Cause you could make them out to yourself.
Signed it already, so you should be.
it? Okay.
You gonna make it out to yourself.
Make it out to yourself.
Okay.
Okay, give us a, now you're gonna do that today?
Yes, sir.
And what's gonna happen if she pays the restitution?
Your Honor, it's not a dismissal for restitution. There is a plea for time served, which with each case.
The
Okay,
But that offer is only contingent on the restitution being paid.
okay, so she go get the check, made out to her, she get the restitutions changed,
In the correct.
and then in the correct format, and then it's still gonna be blank, y'all will fill it out, right?
Yes, Your Honor.
Okay,
And she could even bring them directly to the district attorney's office and we could assess it in each case from there.
okay. And, what day we need to reset these cases to plea them?
At this point, it's whatever's convenient for the defendant, Your Honor.
Okay,
Because she's gonna have to go through and get them cashed out and
okay, what is your schedule like this week? You know,
Well, this morning I was going to do that. And then these calls happened.
okay, so you don't know what your schedule is?
Now I got something I gotta file either Thursday or Friday. I was gonna do the calendar and all that. And I try to file that on Wednesday. So if today is
Tuesday.
Tuesday, I can tell you at 4:30. But off the top of my head right now, I don't know. So I would assume.
Let me shoot, now, do you work?
Yes, sir, and I keep having them as work. Like, I don't work 4 days a week. I miss
You,
the
would you
day.
say you work 4 days a week?
Monday through Thursday, but. it
So you have to
depends-
do it on a Friday? That's the day you don't work, huh?
can we set her for next Friday, Your Honor?
Next Friday I won't be in town,
Okay.
maybe the Friday after.
What date is that? Did you check to see what, Miss, did you check your calendar?
Okay, what day is it for, Friday?
No, it's gonna be
Anytime next
a
month.
Friday, but it's gonna be, not next week, right?
Yeah,
The following.
Not this week and not next week,
June sixth, it's fine.
June sixth,
Big day.
huh?
It's a big day.
Okay. Are you available?
Big
Okay.
day.
Okay,
Omaha Beach.
okay.
Pick up the Nancy's.
So, 7 days after that will be the 13th.
13th of Friday.
Well, Friday 13th.
Well, that's a big day too. But I mean,
If there's a docket, I'm willing to come down and do the police. I'll be here. What day
Um,
is it?
so you can't do it this Friday?
I could tell you 3. I mean, I don't know.
No. I'm just on day sometime.
You can't do it, you can't do it this Friday?
Make up to.
Oh, so you're gonna have to do a work day. Oh, I understand. Um,
Have permission related to your client, Peter?
let's do
Is that
the
permission
20th.
related to your
What's the
client?
20th?
Yeah.
We're gonna reset it for the 20th.
20th
The
of
20th is holiday?
20th of May or 20th of June.
Well, we have to do it on the 13th, because it seems like we're getting further and further back. Do it on the 13th. This will be the only case set that day.
Right. I'm not in a position that bad.
No, I'm just saying, I'm not too, I'm just letting you know that docket, that this will be, okay, we're gonna set it on the 13th,
May or June?
June,
June 13th.
yeah. And you keep those, you're gonna bring those, to the district attorney's office yourself.
Yes, sir.
So if
Okay.
she brings him in early, the case will be, she won't be in court.
If she
She's gonna have
did,
to plan.
but if, yeah,
All right.
She has
hey, let
questions.
me do this here. Is there, oh, that's right, she only could do them on Fridays.
I have a question. Okay, so even if I thought, is it still gonna
free to go as well, and you have a blessed day. You make sure everybody get their resets from the coordinator. Jefferson County Law number 2 is back in session. Court is in session and calls number 25 CCCR 0252. The case is styled the state of Texas versus Marquis Jamon Briscoe. Mr. Briscoe, is that your full name? Mr. Briscoe, would you please raise your right hand? Mr. Briscoe, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Briscoe, you may put your hand down. How are you doing, Mr. Briscoe?
Bless you, sir.
I'm blessed as well. Thanks for asking. Mr. Briscoe, I have before me 2 documents. Let's see, Mr. Briscoe, I just swore, did I swear you in? Okay, now, Mr. Briscoe, I have before me 2 documents. First document is titled Judge's Explanation of Rights, Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to represent yourself and waive your right to an attorney?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Briscoe, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Briscoe, I also have before me a document on my computer that is titled Information. This information was filed by Jefferson County District Attorney's Office. In this information, it alleges that you, Marquis Jamon Briscoe, on or about March 10th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated. This information further alleges that on or about March 10th, 2023, while you operated motor vehicle in a public place in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Briscoe, do you understand what you have been charged with?
Yes, sir.
To this charge, Mr. Briscoe, how do you plead guilty? Not guilty, no contest.
No contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest these charges?
Right.
Mr. Briscoe, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishments. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are 2 sets of initials. First set of initials are on a line next to a box that's checked nolo contendere, which means no contest. Did you place your initials on this
Yes, sir.
document? Second set of initials is below a paragraph that is titled Discovery Admonishment and is next to a statement that reads, I do not wish to have discovery. I waive my right to discovery in this case and choose to enter a plea of guilty and no contest. Did you place your initials on this location
Yes,
as
sir.
well? On page 3 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
On the next document, that's titled Trial Court Certification of Defendant's Right of Appeal. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Mr. Briscoe, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Briscoe, are you a citizen of the United States?
Yes, sir.
State offers State's Exhibit 1, Your Honor.
Mr. Briscoe, the state is offering State's Exhibit Number 1 to be used as evidence in your case. State's Exhibit 1 is the first document that I showed you on this tablet.
Yes.
It is the same document that have your initials in these 2 locations, and it has your signature on page 3.
Yes, sir.
Is it all right for the state to use this document as evidence in your case?
Yes, sir.
No objections. State's Exhibit Number one will be admitted. Mr. Briscoe, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Mr. Briscoe, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
Your Honor, we would ask for 127 days in county jail with credit for time served of 127 days. And we would ask that the court costs in this matter be taxed and retired.
Mr. Briscoe, the state is offering that you serve 127 days in Jefferson County Jail in this case. You will not have to serve any more time in the Jefferson County Jail in this case because you have already served 127 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case will be taxed and retired. And what that means is you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, it will be taxed and retired. Mr. Briscoe, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Briscoe, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Briscoe, this will conclude this case. Mr. Briscoe, you will stand next to the bailiff, follow her direction, and once you finish following her directions, you'll be free to go, and you have a blessed day.
Yes, sir, you too.
Thank you. Okay. Okay, same to you. And take care of yourself. And we hope you have a speedy recovery from your injury. Okay. All right. Okay, put us back in session at clause number 24 CCCR or 2258. Case of style of state of Texas versus Shayna Renee Brown. Shayna Brown was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's better called the name of Shayna Brown at the courthouse door. Shayna Brown did not answer. Shayna Brown has not appeared in court since the court has been in session. The time now is 12:05 p.m. on today's date of May 20th, 2025. Ms. Bailey, would you please call the name of Shayna Brown at the courthouse door?
Brown. Shayna Brown. No response, Your
Okay,
Honor.
Shayna Brown's name was just called again at the courthouse door. Shayna Brown did not answer. A reasonable time has passed to give Ms. Brown an opportunity to appear in court. She has not appeared in court. State, do you have a motion?
State moves for bond forfeiture, Your Honor.
That motion will be granted. Shayna Brown's bond will be forfeited and a warrant shall be issued for her arrest. And cause number 24 CCCR 2258. He was reset. Okay, we have Martavian DeMarcus Evans, cause number 24 CCCR 0914. Martavian Evans was scheduled to be in court this morning at 9 a.m. At about 9 a.m., court's bailiff called the name of Martavian Evans at the courthouse door. Martavian Evans did not answer. Does not appear in court since the court has been in session. The time now is 12:07 p.m. on today's date of May 20, 2025. Ms. Bailiff, would you please call the name of Martavian Evans at the courthouse door? Yes, Martavian Evans.
Martavian Evans. Martavian Evans. No response, Your
Okay,
Honor.
Martavian Evans' name was just called again at the courthouse door. Martavian Evans did not answer. Reasonable time has passed to give Mr. Evans an opportunity to appear in court. He is not appearing in court. State, do you have a motion?
State moves for bond forfeiture, Your Honor.
That motion will be granted. Martavian Evans' bond will be forfeited and a warrant shall be issued for his arrest. And cause number 24 CCCR 0914. Next case is cause number 25 CCCR 0732. Case is style of state of Texas versus Omar Young Sr. Oh, I was a reset? Okay. I didn't have it marked off. What was the reset for? Her. I think this concludes the calling the court's arraignment docket on today's date, May 20th, 2025, in County Court at Law Number 2 of Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. And Mr. Hilton, you are excused.
Thank you, Your Honor.